The writ petition is dismissed.
Obliged. The Honorable permit us to mention item 41 and 42. Item 41 and item 42. These are two writ appeals filed by Star Cement against Competition Commission. It was listed for orders today. Service has been completed. Replies, I think, also been
Yes.
filed.
In one of the writ appeal, we have filed a opposition, and today, and in the second writ appeal, we will be filing today, Lordship.
So the matter may be listed for final
Yeah.
disposal or hearing. No, no, it's for orders today.
Admitted for
No, it's not been admitted. It may be put for admissions.
Which matter?
Writ petition number 366 has already been filed. I believe the other one has been
Yes,
filed today.
367 will be filing it today, Lordship. Writ appeal 367 will be filing it today. In 366, Your Lordship. 66. Yes, sir. 42. Lordship, in the month of in last week of April, Lordship.
25th, 26th, if you're honest. Comfortable.
Okay. Give the date on 26/3/2025.
26th, sir.
26/3.
Yes.
No, let it be on sometime in April, you know.
He said there is urgency in the matter.
Urgency in every case, there are urgency.
No, I don't know if it is.
In
Both
every
of
case,
you-
there is every case there is urgency.
Because there's actually a
No,
stay operating in
we
this.
don't want to show that we have no urgency.
But I think it will be better if April, because March there are other matters. are
April.
first.
Then the first week of April, Your Honor may consider.
Both of you agree to it.
Second,
We also have an arm wrestling room in the bar. You can use that.
Well, next time he will take the adjournment. Your lordship will see.
No, we don't know. I just said that
No, he has-
somebody,
He urgency a lot. Next time he will prefer
no,
adjournment.
Dr. Saab, somebody told me that in the bar now you have an arm wrestling room where you can sort out the differences of dates.
You know, that is always from the past also. They were always it was there when lordship was
So
also.
we agree to a date when.
whenever.
2 तारीख को क्या एक अप्रैल फूल के बाद सीधा से कोई लेना है 7-8 तारीख को ले लो
हाँ, ले लेते हैं सर 6 तारीख को ले लेते हैं 6th on
6th,
or 6th is Sunday. I apologize.
no, 4th.
9th or 10th?
I
9th,
think
Your Honor?
4th of April or 7th of April.
7th?
When?
7th अप्रैल में लो
7th of April.
well
Okay.
lordship may admit it because it will be come up for hearing then
9th? Sir, are you comfortable to 9th? The 9th of April, Your Honor.
No, 9th is too close to the vacations. We may not be able to hear
Very
it.
good.
at all.
7th, Your Honor. We'll take our
7th?
chance on this.
Uh, No, if we admit it for hearing, then not in the first week, then it goes after vacation.
because my lord, this is not a case where the admission hearing it will be closed because it will
No,
take
that's okay. But once we admit it, then we list it in the 3rd week of April,
22nd, Your Honor?
22nd. Okay.
Deeply okay.
The readings will be completed. Stop there. Then say that in view of the nature of grievance made, raised in this inter-court appeal, comma, the will stand submitted for hearing by issuing rule returnable forthwith without requiring any fresh steps to be taken. Next, whereas the pleadings are uh, uh, subject to filing of the affidavit in opposition in this item 43.
It is
Within
filed today.
in course of the day today, comma, let the matter be listed for hearing on 22nd April 2025.
Keep your blade.
Pass separate orders. 4. 22nd or 25.
I'm obliged.
And in the first matter, that affidavit is not required. There we already said that affidavit has come. Okay.
Blade.
May I please, your lordship. My lord, in item number 49 of the supplementary list, my lord. In fact, the matter was listed on last 7th of March 2025. My lord. And in fact, an order was also passed, your lordship.
Oh, no, we are dismissing this petition. Time and again, we say that you please check up your cost title and your affidavit. Name spellings are different. We won't encourage this. Every day we spend a lot of time looking at this and go home beyond 7:38. We don't want to do this clerical job. We are dismissing it. You, with the liberty to come again, you come again. We return your Vakalatnama and the certified copy of the impugn order. But we don't encourage this anymore. We are fed up of checking after dictating the order, checking the dictations, and then we embark on the to find out whether the names are there or not correct. It goes to my table, then it goes to my esteemed sister's table, and we spend all this time with 3-4 people running around just to see whether the names are correct or not. If you don't have time, we punish you.
I am extremely sorry, my lord, because
Sorry doesn't help us.
my lord, I assure
You don't,
that- Yeah.
you don't know. No, this all. We have been telling time and again. This time we are fed up.
my lord, I assure that in my.
No, you file a fresh one. We don't encourage this anymore. We are fed up of it. Please work like me. You come here, assist me, and then go at 7:38, then you will realize the amount of time we are spending here. Every day we can't tell people that you please check if you don't have time to check your own brief. Why should we do all this?
Of
3
course.
people are engaged. One will go to the typist, come back. One will give me the file. The third one will go to my esteemed sister's table, and then the view of my view, it will be explained to her, and then she concurs, and then that matter comes back. So every time, half an hour is spent only on one file because of one mistake.
I undertake that, my lord.
No, it's okay. We are dismissing it. Next time you don't do it. We don't need an undertaking.
I-
Uh, Mr.
Hey, Ali.
A. Ali, learned counsel for the petitioner, as well as all the respondents are there. Mr. M. Islam on behalf of A. Ali for ECI. Are present. Next, this matter was listed
7-3.
on 7/3/2025, and an order was dictated in the open court. First of, however, at the time of transcription and the transcript, it was, it has been noticed that, give that item 47. It has been noticed that 49,
49, well.
that in the cost title, the name of the petitioner is reflected as MD full stop. Sahib. SHAHEB. Ali. Whereas in the affidavit filed in support of the writ petition, the name is only mentioned as Sahib Ali with omission of MD full stop. Next, whereas the name of the cost title and the affidavit is in variance, the order which was dictated on 7/3/2025 was recalled, and the matter is listed afresh today. Next para, in view of the variance of these, where the name of the petitioner is spelled in the cost title as well as the rate petition, sorry, affidavit in support of the rate petition, the court is inclined to dismiss this writ petition. Full stop. However, with liberty to the petitioner to approach this court again. Next para. The next para, the registry shall hand over the wakalatnama as well as the certified copy of the order to the petitioner and on being furnished with a photocopy of the both the documents to be retained in the record. You can take back your certified copy and the affidavit. Sorry, the wakalatnama.
Obliged.
Yes.
Lordship, with the consent of the other side, I beg to mention item number 9. Lordship, 2 weeks time may be allowed, Lordship.
Okay, you gave an adjournment slip. Okay. Both sides are represented. On the prayer made by learned counsel for the petitioner, the matter stands adjourned today. List after
2 weeks, my
2 weeks.
obliged.
May please, my lord. I beg to item number 19, my lord. My lord, this matter will follow for the day, my lord.
It
Mr.
goes after 2 weeks.
My lord,
Item number
19, my lord.
19. Okay. Same order, 19.
Obliged.
Item 11 and 14 million, may can be taken after Ramzan. Million.
Okay. Give us the date when estimated time which
Millet, April, any date Millet.
last week.
April, any date Millet, first week, second week.
Okay. You see, same order. This one 2/4/2025. Okay. Okay. Item number, please tell the item numbers again.
11 and 14 Millet.
11/14. Okay.
Obliged.
Yes.
May it please the lordship, I beg to mention for item number 4, after 1.
4 is 2018 matter. Okay. After 2 weeks.
Upgraded item 44.
What is the error in the order?
What is in paragraph number 6 and 7?
Number 6 and 7.
7.
What is the mistake?
Mr. Superintendent of Police, actually Borpeta.
It should be Borbeta.
Borpeta.
Is it repetition? No, it's okay. We have it. Yes. No, you'll have to file a fresh application. This, the application in the present form cannot be entertained. It is not a mistake of the court. Is it a mistake in the order? Or that is the cost title you had supplied? In the repetition, what is the cost title of the Superintendent of Police border? You are taking so much of time. Just to read your cost title, you are taking so much of time. You ask assistance of somebody else, ask Mr. Sharma to read it. Show your petition's cost title to him. You can't take so much of time in reading a cost title.
Yes. Bucks, sir.
Then how can we alter the order?
Typical mistake.
We don't know, you correct the application. This, by filing this, Mr.
And Islam.
And Islam, then counsel for the applicant. All the responses are there, same. Next one. Filing this interlocutory application, comma, the applicant is seeking correction of the typographical error which is crept in the order dated 25/11/2024, passed in WBC 5080/2024. Next paragraph. On a perusal of the cost title. No, say the Learned Counsel for the applicant has submitted that the competent authority to grant bail is the Superintendent of Police, Border, Borpeta. And that in the order, that in paragraph 6 and 7 of the said order, comma, the concerned authorities noted as Superintendent of Police, Border, Baksa. Next paragraph. The description of the said authority in paragraph 6 and 7 of the said order is found to be in consonance with the cost title of respondent number 5 given in the writ petition. So accordingly, we don't find any mistake in the order which requires correction. Next, accordingly, this interlocutory application stands closed. Next, however, comma, the applicant is at liberty to file the separate interlocutory application for correction of the cost title of the connected writ petition, which will have consequent, which, comma, if allowed, will have consequential effect on the order.
Then 45.
Yeah, please, Your Lordship. Your Lordship, my need a matter be passed over for time being. My senior is on Dex in court number 12.
Item 46.
Yeah, please, Bucks.
Yes,
I for my lord extension of time, my lord. My lord, earlier occasion,
23 order, you have come in 25.
my lord, one IA has been filed, my lord, in between, my lord. That was withdrawn, my lord. That, whereas 7 I have stated, my lord. Due to some, my lord, wrong statement, that IA was withdrawn. And thereafter, this IA has been filed. Ground মানে হয়তো একটু হয়েছিল কিন্তু মানে অসিস্ট্যান্ট আছে সব
এখন নাই পোৱা নাই।
গ্রাউন্ড টু ফোর
But Mr. Ahmed, you'll have to record your apology to the Superintendent of Police. His mother was alive, you made her dead
my lord, there.
just for the purpose of extension of time.
Yes, my.
We'll record your. His case was that the Superintendent of Police, he went to the police to take bail, but the mother of Superintendent of Police had died, and therefore he was not available. When we issued notice, the Superintendent of Police comes and says that no, his mother is alive. Mother was never dead. So we withdrew that application and now he's coming afresh. We record your apology because he needs an apology. We issued him a notice whether his
Yes.
mother is alive or dead.
Yes, my.
He responded by saying that his mother is alive. Mr. Sharma, we extend time.
Lordship.
And Mr. S. A. Ahmed, on counsel for the applicant. Respondents are same. Next paragraph. By filing this interlocutory application, comma, the applicant is seeking extension of time to approach the Superintendent of Police, Border Buxa, and take bail in terms of order dated 22/11/2023, passed in WPC 6697 of 2023. Next paragraph. The learned counsel for the applicant, comma, at the outset, comma, prays that his apology be recorded to the Superintendent of Police, Border Buxa, because on an earlier occasion, by filing ISC 3206 of 2024, comma, the applicant had made an incorrect statement that the mother of the said authority had expired, for which, although the applicant went to the office of the Superintendent of Police, Buxa, Border Buxa, comma, the said authority was not available. So he submits that due to erroneous instruction, the said fact has been recorded, and therefore his apology. Next paragraph. You write all these things, we can't do anything. You see, now your story is what? Now your story is that you could not appear before the authority because the learned advocate was engaged in another case.
That is fact.
Now another case means day in, day out, 24/7 into 7 days. We don't have, I can assure you, we don't have an officer who can work for 24/7 for a week.
I have taken this instruction from the advocate, my lord.
But
I personally
if you have such
asked
a
him.
busy advocate, I would love to meet him. We'll just ask few questions on the procedural law and then test his knowledge. How busy he is. This again is a false statement.
No, my lord, I personally asked him, the advocate.
No lawyer, I can assure you. I had been in trial court. I have seen busiest lawyers who had briefed not in dozens. They had briefs in thousands. And they were always free. I don't know about others, but the lawyers I have met, they had large practice. I had the fortune of being groomed up with them, by them. Mr. Sharma is here. I can't say about others, but Mr. Sharma is there. His senior is one of the busiest. He still is. He was then also one of the busiest lawyers, but he always had time for everything. Correct? He was always free. I had the fortune of meeting Mr. A.M. What do you call? Mr. Abdul Mahim Muzumdar. His table was like a huge mela. And he had all the time in the earth. So therefore, I need to meet and know this man. Lawyer is always busy. I don't know, but this is a story we can't accept. If you accept this, there's nothing. It's all. I don't know where John it. This explanation is not acceptable. You have today is attendance is few of your friends sitting behind. You go and just like in Kaun Banega Crorepati, we have that phone a friend. You talk to a friend. If he or she is convinced, we allow it. You go by Kaun Banega Crorepati. No. Just say that what says the representative on the ground set forth for extension of time to take bail is not found convincing. So accordingly, the matter stands adjourned today. So as to enable the learned counsel for the petitioner, the applicant to take instructions and address the court. At least after a week.
47.
Obliged.
Earlier order is going to-
Please, your lordship, filed a IA for consideration of interim prayer lordship. The case was first listed in the year 2018 and since then it was not listed. And in the meanwhile, the police was searching the petitioner to arrest, so in a hurry. Yes, lordship, 2018 matter, and so under the apprehension of arrest is instructed to file this IA lordship.
What is the date of the opinion?
Date of opinion, lordship, page 56, lordship. 28/5/2018, lordship,
28/5.
2018.
Mr. Sharma, the cards are received. It will take some time because it's voluminous.
Yes.
And in the meantime, we see that the writ petition was filed on 1/8/2018. Grant him bail.
Yes.
We are granting you bail.
Lordship, obliged.
Heard Mr. Zaid Hussain, learned counsel for the applicant. Also heard names of the respondents. Your name?
M. Kalita on behalf of people.
M. Kalita on behalf of Ms. P. Barwa. Standing counsel for ECI. By filing this interlocutory application, the applicant is praying for suspension of the opinion impugned in the connected writ petition and obligor to allow the applicant to go on bail. Next para. The learned counsel for the applicant has submitted that notice in connection with the connected WPC 6999 of 2018 was issued on 9/10/2018. And since then, the writ petition was never listed. Post of however, comma, during the that in the meantime, the police authorities are searching for the applicant. So accordingly, comma, it is apprehended that the applicant may be taken into custody pursuant to opinion is at which page?
Opinion is page 9 of IA and 56 of the writ petition, and in the IA it is also annexed, lordship.
Okay.
It is at page 9, lordship.
Just
Page 9 of the IA.
9 of the IA.
28/5/2018. Date of opinion.
Opinion date 28/5/2018, past page 9 of the IA. Filed by so and so and so and so. By which the applicant was declared to be a foreigner of post 25/3/1971 stream. Next paragraph. The prayer for bail is opposed by the learned standing counsel for the FT matters on the ground that the applicant has could not be apprehended for about 7 years now, despite efforts by the district administration and the border police. So it is also submitted that as the records are received, all matter can be heard and disposed of. Next paragraph. It is noted that after 9/10/2018, the connected writ petition was never listed. And this interlocutory application has been filed on 26/11/2024 and was reported by the registry on 1/2/2025. Moreover, the examination of the records received would take some time. So under such circumstances, court is of the considered opinion that the applicant be granted bail. So accordingly, it is provided that the bail of rupees 10 days time to take bail, or rupees 5,000 to the satisfaction of
SP Borpeta, lordship.
SP Border Borpeta. The connected read petition, you pass separate order. The IA said that the application is allowed and disposed of. In the read petition, you say that by Hertz Winslow, by not by pursuant to order dated 9/10/2018, the petitioner has taken steps for service of notice on the respondent number 7. As per office note dated 7/8/2024, neither ED card nor unserved notice has been received back. Accordingly, the petitioner shall take fresh steps for service of notice on respondent number 7. Take steps within 2 days for service of notice on the respondent number 7 by registered post with ED. Next paragraph. The notice is made returnable on, give a date after 4 weeks. And returnable on so and so. Next paragraph, the learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph, list on so and so.
23rd April.
Blank.
Item 1 for motion.
Yeah, it will.
Yes.
Earlier, LCR was called for your lordship and LCR has been received, your lordship.
Yes.
My lord, I am in custody from the date of your lordship. 20.
What is the best document you have to connect yourself to your projected parents?
My lord.
Which page is your written statement?
No, it is not contested matter. Yes.
It's not contested.
No, my lord. It's the expert is husband, your lordship. Kindly come on page number 39, your lordship.
39. But then you have not made out a case for interference by this court. You appeared before the tribunal and took adjournment on 1, 2, 3, 4, 5, 6 dates. And the order sheet shows that after last chance given to you, this opinion was passed. You by 23/8/2018, the order says that the OP has already been given for adjournment on so and so with warning as last chance on 1/8/2018 and 14/8/2018. So after that, you were given a final last chance. You see your explanation given in paragraph 14 and 15.
Yes, my lord.
If read together, would mean that after 2018,
Yes, ma'am.
you never connected, sorry, you never met your lawyer.
Yes, my lord. Actually, I am a
And
work
and on 26/12, you engaged another counsel to obtain certified copies of the order. So
Yes,
if
ma'am.
you are not
After my
in,
arresting, your lordship.
that's why after you see, the previous experience I had, I don't find any lawyer anywhere in the country who takes steps without receiving fees, without the client coming.
But my lord, on that time, my lord, I am a old age person, your lordship. The engaged council demanded huge money, your lordship. So I
Definitely,
returned back to home,
definitely.
my lords, I could not prepare my money. And,
Everybody is searching for a
not
lawyer who does not
communicate-
charge money. They are in great demand.
So I could not communicate with my lawyer, your lordship. But he withdraw his Okalatama, but he did not inform me, your lordship. Nothing, no any
No,
notice.
you'll have to show that you were in contact with the lawyer. Lawyer, if you don't pay him, will definitely withdraw the wakalatnama. In fact, we are all searching in the legal aid committee. We are searching for lawyers who don't charge fees.
Judgment was passed on 2018, your lordship, and my lord, I am arresting on 2024, your lordship, after 6 years.
You can't help it. Here also, you are not been able to make out a ground. You have not said that you. You see, it's not a complaint of yours that the lawyer demanded X rupees as fees, and after receiving X, he was demanding Y. That's not your case.
My lord, on the other hand, your lordship, I have submitted every document, your lordship, except my.
But we can't do anything. You have to
total
first
to the
first
reality.
demonstrate that your conduct was cooperative with the tribunal.
And my lordship, he has been taken a step without communicate with me, your lordship. Day by day, he has been taken.
You see, that is the precise reason we were compelled to have the phone numbers of the clients taken in this court, because this was a routine reply that they are not in contact with the council. The council is not in contact with the clients. Therefore, we had to amend our rules, and now we are requiring the people who are filing affidavits to give their phone numbers.
I am a 64 years old, your lordship, kindly. Once
So, but you'll have to demonstrate that you had. You'll have to demonstrate that you had you were in touch with your counsel.
But on the other hand, my father's name is in the 1970, your lordship. And actually, my lord, the notice was served me to as a wrong,
Mr. Islam,
wrongly.
we are, for a moment, we are not saying that your story is false, but it doesn't inspire any confidence. You don't make a complaint against your lawyer. You don't file any complaint. He is not even a party here. That the lawyer withdrew wakalatnama without instructions. We can't accept it, because all lawyers will definitely, without being paid, will withdraw the wakalatnama. What is wrong in that?
That on 27/8/2018, the youngest advocate would do his Ukalatam.
Correct, definitely. He does not want his name to be in a defaulters list of the tribunal. You may not know, but you see, even we take note of. I'll just tell you, you will understand. Every time we have court references for the death of a lawyer, on a death of a judge, honorable judge, correct? You please be in the reference, and you will find not a single lawyer having criminal practice will be there. 2 or 3 people are always there. I won't say their names, but they are found. And majority of the lawyers don't even respect their own dead. They don't come. And therefore, we had taken a resolution in the High Court curtailing the time for reference. Earlier we had 4 or 5 learned lawyers and the advocate generals giving their reference speech. Now bar invited reference. Now we don't give that amount of time because at times we find speakers are more than the audience. So we take note of that also. You'll never find any lawyer with criminal practice in the criminal side available in the full court references. We take note of that. So you tell me which lawyer will do that kind of service? And what is wrong in that? To withdraw the wakalatnama.
Should notice me, your lordship, on the other hand, my lord, because my address is there also with him. So my lord, he maybe notice to me, your lordship, about the expert judgment, your lordship. So my lord, I am come here 2024, your lordship.
Need to give us supplementary.
My lord, I am a very humble player, your lordship, kindly.
No, you just make out
consider
a
your
case.
lordship. As per the last
We,
order.
we set aside the when I don't read law books, I read Wakalatnama. Have you ever read it? Your Wakalatnama? Look at the last line, 2 lines. In case of non-payment of stipulated fees.
And we agree to ratify and confirm all acts to be done by the said advocates as mine hours for all intents and purposes. In case of non-payment of the stipulated fees in full, no advocate will be bound to appear and act on my own behalf. Yeah.
Correct. So that's why I said your statement in the representation does not, your interlocutory applicant does not inspire confidence. This is a major thing.
Yes.
If the lawyer has made a disclaimer not to appear without payment of stipulated fees, how can you find fault with the lawyer? How can you condemn the lawyer? If you can't condemn the lawyer, we can't allow your petition. As simple as that. You try to do what you want to do. We adjourn it for a week. All sides are represented. The explanation for a delay in challenging the impugned opinion is not found inspiring. So accordingly, the matter stands adjourned today on the prayer made by the counsel for the applicant so as to enable him to take instructions and to make his submissions list after a week.
Any date will fix this, otherwise.
When do you want? Karas?
Twenty-fifth, 6 months.
Huh?
Or after 1 week, no.
No, whenever you say, we will fix it.
24th
24th of March? Okay, 24th of March.
Mass obligation.
Item 2.
Please, your lordship. Well, in a peculiar situation, the petitioner has to approve this.
2018. 2018 opinion.
My lord, 2018 opinion earlier approves and this one court has set aside the impugned opinion, then my lord remanded for fresh consideration.
Okay.
But the tribunal has proceeded for
Okay,
cross
it's
examination,
February 25.
my lord.
Okay, we give you bail then.
My lord, he is in already on bail, my lord, that's what in terms of the previous order. My lord, he was declared by foreigners, then he approached this honorable court. This honorable court has set aside the order and remanded for fresh consideration. In
Okay.
fresh consideration,
Yes.
my lord,
This is the order and the challenge then
my lord, at page 28, my lord.
28.
My lord. The learned tribunal wants to cross-examine the witnesses again, my lord. Very aggrieved because of this, my lord. How this can be done, my lord.
Let us see the directions contained in the order.
My lord, lordship may kindly have a look at the relevant portion at page paragraph 18, my lord.
18.
18, my lord, page 21. Therefore, the scope of the court in exercise of jurisdiction under certiorari is limited to examine whether the opinion of the learned tribunal is sustainable or not. Having found from the discussion above the said opinion is untenable, the only option available to this court is to remand the matter back for a fresh consideration by the consideration and opinion of the learned tribunal by setting aside the impugned opinion passed by the learned tribunal number so and so. Well, it was only for fresh consideration. How the tribunal now go for fresh cross-examine, my lord, the defense witness who were earlier done, my lord.
Mr. Sharma,
Lordship.
have you seen this order, page 28?
Yes, Lordship.
Your government pleader is not asking for time to cross-examine the witness. Court
No.
cannot compel that.
Yes, Lordship.
The state may come up and say that we want to cross-examine. But state is not coming forward. Tribunal is not business to cross-examine.
Yes, Lordship.
Please take instructions. We'll pass orders at 2 o'clock.
Lord.
You consult your authorities
Let it
because
come up on tomorrow, Lordship.
tomorrow. We'll take it up at 2 o'clock. That is better. You can have consultation in your at lunchtime and then we'll take it up at 2 o'clock.
Perhaps I am not available at 2, Lordship. I will be here, Lordship.
Okay. Okay. Just show him this because the tribunal is not supposed to cross-examine.
Yes, yes.
Had the state taken up the call, we would have not interfered. The state is not taking a call to cross-examine.
Yes, Lordship.
Check up.
Item 3.
But tomorrow we may have a special bench. We don't know. That's why. At 2 o'clock.
Well,
Let him take instructions. We'll
well,
fix another date after that if they have some difficulty. Yes, Mr. Amir.
Opinion is, my lord, 2023, my lord. At page, my lord, 81. 11,
Just a moment. Which page is the opinion?
My lord, page 81.
Page 81.
81, operative, my lord, at 82. And my lord, after filing.
Mr.
My lord.
Ahmed, please don't take a risk without checking your name in the cost title and the affidavit. If it is wrong, we'll dismiss it with liberty to approach again. Have you checked up?
Yes. Respondent number 5. 5 and 7, Lord. 5 and 7.
No, 5 he has corrected. District Commissioner, he has made that.
I am sorry, my lord.
Correction is made
I
here.
filed, my lord, amended cost item.
You've seen your name in the affidavit. Spelled differently.
My lord, in my read petition,
I don't know where your affidavit is. In my copy, it is always with the writ petition. Hasena Khatun, second name Hasena Khatun, in affidavit is UN. In your cost title, it is OON.
Sena Khatun, alias Hasina Khatun. Yes, please. Oh, yes, my lord.
It has become my business to look into mistakes now. Now, where is the mistake? In your affidavit or in the cost title?
No, the affidavit is correct, my.
Affidavit is correct.
Title
Okay.
is double, not double O, my.
Okay. The current council, also as a representative. Next, Mr. S. A. Ahmed, and counsel for the petitioner, pays for an granted liberty to amend the cost title of the petitioner by submitting a type, freshly typed out cost title to the AOJ FT section. Just, we shall be done within 2 days. Also, let the matter be thereafter listed before the vote in the motion column.
One thing, my lord, in the opinion, my lord, the Khatun is mentioned, my lord, KHA.
No, we don't know. I am personally not aware of the spelling of the
Yes, yes.
petitioner. It is for you to take instructions and do it. If the mistake is in the affidavit, you file a fresh affidavit. If it is in the cost title, file a fresh. So what
Okay.
what should we write in the order? Affidavit or cost title? What do you want to correct?
Affidavit.
Affidavit. Substitute the affidavit. No, the amendment of cost title is not required. Then don't say 2 days. As and when the affidavit is substituted.
In her written statement, Lordship, it was
No,
written.
I
Yes,
don't apply my mind there.
Lord, I only mentioned KHA WT1 because, my lord, in the.
No, I don't know. It is absolutely
has
your,
been mentioned.
it is absolutely your discretion. You
Yes,
want,
my lord,
how do you want to spell your name? It's for you to decide. I don't apply my mind here.
Yes. Obligement.
Item 5.
Definitely, Mr. Ahmed, you also don't want us to apply our mind in your name. Yes. Item number 5. No representation from the petitioner. For range of justice, the matter is adjourned today. List on date 24 February. You just also add that records of the travel is received. List on so and so.
Item 6.
Yes, Mr. Sheikh. After some time. Item 7.
Please, sir, Worship, the matter may be taken up after some days, my lord. I have to go through the records, my lord.
Item 7.
Yes, my lord.
Okay, after some time.
And not after some days, my lord, after some.
After
I
some
have-
days.
Yes, sir.
Okay. List after the as paid for and cost for the petitioner. Okay. Yes, item 8. Nine. Next call. Next call. After something. Yes, item 10. Yep, after some time. Yes, item 12. Yes,
My senior is on his way.
after some time.
Okay.
Where is the school certificate?
Lordship. School certificate, transfer certificate is page 72, Lordship.
72.
Lordship, in this one, Lordship. And the record, I think, Lordship, transfer certificate 37. In the record 37 and
And where is your written statement?
Lordship written statement or it on page. Page is 30, type copy 30. Sorry, Lordship.
Page number
Yes, lost,
24.
lost 24, lost, yes. And the recording 17.
And where is the Jamabandi?
It's a Mamandi,
Exhibit 7 and 8, the sale deed and Jamabandi.
Samavandi, Lordship, page 67, Lordship. Indeed, Lordship. P4 onwards, okay. Tinta. Nine and 62.
But still you're not been able to prove the land documents.
One, Lordship, one thing, Lordship, in the voter list, Lordship, page 52, Lordship, I coming later, on page 52, Lordship,
52, yes.
Lordship, Rafiqul Hussain, Lordship, and Hussain Ali, the father name, Lordship. And page, Lordship, page 46, Lordship, 65 voter list, Lordship,
No, you see, come by one by one these documents.
that,
This
legal-
sale deed, there are two sale deeds.
Lordship,
One is at page 54,
Lordship,
type copy.
Lordship,
The vernacular is at page
Lordship,
56.
56, Lordship,
The other sale deed is at page 61.
Lordship,
You see, the purchaser of the property is Miadhar Sheikh,
Lordship,
correct?
Lordship.
Now look at the Jamabandi. The Jamabandi is at page
Page 67.
68,
Type copy.
correct? I come to remark Gho. Chokrovikha Imam Tarikor Chita Hukumate. Atada Raho Hukumate so and so. Hussein Ali Pita, it is so and so Namjari Hoy. Correct.
Lordship,
But the vendor is the purchaser is somebody else.
this is
Purchaser is your father. No, no. Purchaser is the father.
Lordship, this is third sale deed, Lordship. 62, Lordship, third sale deed, I think. Page 62, Lordship, third sale deed,
62.
Lordship. Agreed, seven, Lordship.
Mr. Sharma will grant bail because after notice of motion was issued in 2018, today is the first date it has been listed.
No.
Okay.
But, Lordship, last order dated Lordship 24/8/18 Lordship, that the petition shall not be arrested and did not debated. That order is there. Lordship.
Okay, okay. Then we admit it and fix it for hearing.
Lordship.
But this as mayor and council for the
Not
petition,
disposing to sales. Not disposing to the Lordship. No,
Pardon me?
no,
will not be able to.
Lordship. Because only the name,
If you-
pronunciation name.
If you want a disposal, you
No,
have to
no.
wait for, wait till the last. If you
No,
time,
no,
we-
no, no. As you know.
As per the petition, responses are there this time as well for AI Ali. Pursuant to order dated 24/8/2018, all the records of the tribunal is received. The examination of the records will require some more time. Next one. The request has admitted for hearing by issuing rule returnable forfeit without requiring the petitioner to take fresh steps. Next one, this is the matter for hearing. In the month of June 2025.
Obliged, Lordship. Pronunciation of name, Lordship, Hussein, Lordship.
We've seen everything.
Obliged, Lordship.
15,
Pass for the timing. What is there? Pass over the timing. Item 16.
Lordship, my senior leg in another court, Lordship, may adjourn the matter just for timing, your Lordship.
Okay.
Highly obliged.
Yes, 17. Pass for the timing. What is there? Item 18.
The matter may be passed over for time being.
Time being. Okay. Next, item 20.
This is not paying for time, but to extend. The learned senior counsel is.
You want an adjournment?
Yes, Lordship.
How much time?
2 weeks.
What says the representative? Now the they made back cost for the petitioner just after 2 weeks.
Hello.
Yes, 21.
Against that opinion dated 31/5/28, 2018, my lord. Page 26 is the opinion. Now, lordship, in this case, the petitioner submitted total list from 1965 onwards, my lord. 1965 is
What is-
further-
What is the best document to connect you to your parents?
Lordship, my name itself appeared in the total list of 1970, my lord.
1970,
My lord, page 31, my lord.
page number?
Page number 31. And particular at page 32, lordship. T. Narayan Burman, son of Jyotishthir, my lord. Prior to this, my lord, the total list of 65, where is my mother's name appear, my lord, Jyotishthir Burman. Page 29, my lord, particular page 33. All along same constituency.
Just a moment.
Lord.
What are the documents exhibited by you? We are unable to find out.
Lordship,
Exhibit 1, what is exhibit 1?
19, total list of 1965, my lord.
1965.
Yes, the father of the petitioner, my lord, Yudhishthir Burman.
Which page?
Page 29, my lord, particular and type copy, translated copy and particular at page 30, my 30. The certified copy. Then exhibit to my lord, page 32.
What is wrong in the appreciation of documents? The
No, my lord,
requirement of the act and the order is that you must be in continuous stay in the country.
my lord, the tribunal, page 28, my lord, held that as I have not proved the total list exhibited from 1965 onward, my lord.
Yes, after, you see, after 1970, it is 1985, 15 years.
Lordship.
There's no explanation of being in India.
Only thing, my lord, in his WS, it is stated that in all along from 1970, his name appeared, my lord. But while exhibiting, my lord, 1970 and 80, then
Even
85.
before this court, you have not exhibited any document. You have not produced any document to show that your existence was there.
No, my lord, last and next year, my lord, my voter ID, my lord, as well as last and next year, my lord, it's voter list of 2005, my lord. Until today, my lord, is laying here.
2005 is again post 1985 document coming into existence after 20 years.
Lordship.
The tribunal is disbelieving 15 years and you ask, you want us to accept it for after 20 years.
In that event, my lord, I may be allowed to bring on full total list, my lord. And apart from this, my lord, the tribunal held it as I have not proved the total list, certified copies of total list of 1965 and 70, my lord. These are the certified copies, my lord. 1965 and 70, my lord. Lordship would see page number 28, my lord. On para 10, on appreciation of supplied documents on record, required that name of Yudhishthir Burman, son of Kena, appeared in the electoral roll of 1965 at sons of the name of Narayan Burman appeared in the same village in 1970 electoral census, also 97 with age census. The name of Narayan Burman also found in the electoral voter census. These documents remain not proved as this has not been proved by appropriate authority.
Sharma, in your, in this opinion of the tribunal, there's one good part and one is bad part.
Lordship.
You come to page 28. It is, these two exhibits are rejected on the ground that the certificate copies were not proved by the authorities.
Yes, Lordship.
I don't think any law says that the certificate copies were required to be proved by the calling Election Commission of
No.
India. Correct.
Yes,
So this is a good, this is a bad part.
yes,
The good part is that they say that between 15 years, there is no document.
yes.
But it could have been rejected on that ground. But once this is added, you have to remand it. It has to be considered.
Lordship. Yes, Lordship.
Whatever it is worth,
Yes, yes, Lordship.
it has to be considered. Then it can be rejected on the ground that there is no connecting documents.
Otherwise, other parties.
Other points are okay.
No.
But old economics theory, good money bad money drives good money out of circulation.
Lordship.
You know the theory, no? You don't know the theory. You see, in your purse, if you have soiled notes, you will keep good notes and then pay off somebody with bad note.
Yes.
So in economics, there's a theory. It says that bad money goods drives good money out of circulation.
Lordship.
It's a well-established principle in economics.
Lordship.
That's a universal theory. In your purse, you will always keep good money, and bad money you will try to spend.
Lordship.
This is that theory here. Bad money drives good money out of circulation.
Lordship.
Okay,
Yes,
we'll
Lord.
pass out a
Yes,
take
Lord.
break and come back.
Yes.
Heard. Mr. J. Leskal and counsel for the petitioner. Also heard. All the respondents are there. Huh? Respondents are there. That's also. Next further. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 31/5/2018, page 26, passed by so and so and so and so, thereby declaring him to be a foreigner of post 25/3/1971 strain. Next para, upon receipt of notice, the petitioner appeared before the learned tribunal and had submitted his written statement. Denying that he was a foreigner and claimed that he was born and brought up at village Barika, Barikadanga, Barika Danga, Moza Madhyam, Madhyam, Madhyam Baksa, Baksa, in the district of Baksa. First of his father's name is Judhishthir, Judhishthir, Judhishthir Burman, and his mother's name is Premabala, Premabala, Premabala Burman, who were residents of the same village. First of the petitioner claimed that his father was a voter of he was a voter in the electoral roll of 1965, and his name appeared in the electoral roll of 1970. Accordingly, he was a citizen of the country. Next paragraph. In support of his defense, the petitioner had also filed his evidence on affidavit. And exhibited the following documents. So, Sharma, something wrong in the record. What is it? Before this, add one more paragraph. Initially, the case proceeded ex parte against the petitioner. And according to the petitioner is approved. And accordingly, the order to proceed ex parte against the petitioner dated 11/10/2017 and 30/12/2017 was assailed by the petitioner by filing WPC 985 of 2018. This court by an order dated 23/2/2018 set aside the orders dated 11/10/2017 and 30/12/2017 and directed the petitioner to appear before the tribunal along with his written statement on 22/3/2018. So accordingly, the petitioner appeared before the learned tribunal and filed his written statement. Then earlier paragraph will come. Yes. You see this record. Mr. Sharma, Mr. Sharma,
Yes, sir.
that matter is today, fixed today.
It's on 17.
Okay, no, I saw you. I thought that you were waiting for that. Okay. You've seen that record, the flagged one.
Yes, Lordship.
Now turn over to next page. That evidence exhibit 1 is striked out. Correct.
Yes, Lordship.
But the original document is exhibited. It is signed by the tribunal. You will find it few pages before that.
Yes. Exhibit 1 is 1956 certified copy and it is 1965, Lordship. 1965 was exhibited
Huh?
and
Oh, acha, acha.
yes.
Just back.
56, total list was not available, certified.
No, we don't know. It's striked out. So,
Yes, 1956 was struck out.
okay. But then the corresponding correction of the evidence on affidavit ought to have been allowed.
Lordship.
Now, according to the evidence on affidavit,
Yeah.
65 is certified copy is exhibit 2,
Yes, Lord.
whereas the document which is signed by the tribunal,
Exhibit 1.
that is exhibit 1.
Yes, Lord. So that has to be corrected.
And the last paragraph, we're saying that in support of his defense, the petitioner has filed his evidence on affidavit. On a perusal of the record, it appears that exhibit 1, in the evidence on affidavit, was the certified copy of voter list of 1956. Full stop. Paragraph 6 of the evidence on affidavit has been struck off. So, however, the subsequent exhibited documents which were marked in the evidence on affidavit as exhibit 2 to 5 are found to have been exhibited as exhibit numbers 1 to 4. And exhibit 5 is the elector photo identity card within bracket EPIC EPIC bracket closed for short. Sorry, EPIC for short bracket closed. Thus, there is no corresponding correction in the evidence on affidavit regarding exhibit exhibits, comma, which are ultimately marked as exhibit 1 to 4. The petitioner had exhibited the voter list of, electoral roll of 1965 containing the name of his father, his projected father, as exhibit 1. The electoral roll of 1970 containing his name has been exhibited as exhibit 2. Add them together. Exhibit 2 is 1970, exhibit 3 is 1997, and exhibit 4 is electoral law 2005. So make 3 together. Huh? So are respectively marked as exhibit numbers 2, 3, and 4 respectively. 2, 3, and 4 respectively. And the epic is marked as exhibit 5. Next paragraph. The records revealed that there was no cross-examination of the petitioner who had examined himself as PW1. Next paragraph. The learned tribunal, while appreciating the documentary evidence in the final opinion, amongst others, held that the petitioner had not disclosed all the required basic material facts in the written statement, which were within his exclusive knowledge. So the electoral roll of 1965, 1970, 1997, and 2005, which were marked as exhibit 1 TO2, exhibit 4, were discarded on the ground that those documents were not proved by the appropriate authority. Moreover, on the ground that the petitioner had not submitted any document between 1970 and 1997, the exhibited electoral rolls were discarded due to the age discrepancy contained therein. Moreover, exhibit 4 was discarded as the same was not reflected in the written statement of the petitioner. Resultantly, it was held that there were multiple material contradictions which rendered the evidence of the petitioner as highly improbable. And accordingly, by holding that the petitioner had failed to discharge his burden as required under Section 9 of the Foreigners Act, 1946, held the petitioner to have entered into India illegally after or on or after 25/3/1971 from the specified territory. And accordingly, he was held to be a foreigner. Next paragraph. Heard the submissions made by the learned counsel for the petitioner as well as the learned standing counsel for the FT matters. Full stop. While the learned counsel for the petitioner has made his submissions against the impugned opinion, comma, the learned standing counsel for the FT matters has advanced his submissions in support of the impugned opinion. Next paragraph. Next paragraph. The impugned opinion is being examined under two compartmental parts. Full stop. One part relates to the discarding of the evidence, evidence in form of Exhibit 1 due to Exhibit 5. The other part relates to the non-availability of documents between electoral roll of 1970 and electoral roll of 1997. Which in other words is that the petitioner has no documents to exhibit between the year 1970 and 1997, which is a gap of 27 years. Next paragraph. With regard to the second part, the learned standing counsel for the FT matters has submitted that once a person is suspected to be a foreigner, he is required to show his continuous stay in the country under section, which provision was that?
6A2.
6A2. 6 within bracket is 6 capital A within bracket 2. Of the Citizenship Act, 1955. Within this A, there will be no bracket. 6 capital A within bracket 2. We find force in the submission made by the learned standing counsel for the FT matters in this regard. Full stop. Once the petitioner is a subject matter of inquiry before the foreigners tribunal, it was his duty to make appropriate disclosures in the written statement and to establish that he was staying in the country continuously prior to 25/3/1971. Full stop. On this count, the petitioner has miserably failed to show and prove that he was a resident of the country. He was an ordinary resident of the country between 1970 and 1997. Next paragraph. The other part which relates to the rejection of Exhibit 1 to Exhibit 5 as an admissible evidence. It is seen that Exhibit 5 is the electoral, epic of the petitioner. Full stop. In this regard, it is a trite law that epic of the petitioner is not a proof of citizenship. Please give the citation of epic not being admissible.
Lordship, epic. Yes, Lordship, Babul Islam. Lordship, I will quote.
In this regard, we may refer to the decision of this court in the case of Babul Islam versus State of Assam and others. Sorry, Union of India and others. Give a gap, he will give the particulars. Next para, however, comma. As regards the finding of the tribunal that the electoral roll of 1965, 1970, 1997, and 2005, which were marked as exhibit numbers 1 to exhibit 1 TO2, exhibit 4, were not proved by the appropriate authority and therefore discarded, is not found to be sustainable. Full stop. The records of the tribunal disclose that the petitioner had exhibited the voters, the electoral roll of 1965, 1970, 1997, and 2005, which were duly issued certified copies. Full stop. Exhibit 1 is the electoral roll of 1965 of village Borika Danga. Borika Danga, what would be the spelling, English spelling? What is the English spelling you have given? Borika Danga. Barikdanga. Barika Danga. Which contains the name of the projected father of the petitioner, namely Yudhishthir Burman. So the electoral roll of 1970 containing the name of the petitioner, of village Borika Danga, is marked as Exhibit 2. So in this said electoral roll, the name of the father of the petitioner is stated to as Yudhishthir. The electoral roll of 1997, which is marked as Exhibit 3, contains the name of the petitioner and his father name is Yudhishthir. Comma of village Borika Danga, oblique Khairani. Khairani, how will you spell it?
K-O-I-R-A-I. K-O-I-R-A-N-I. Page 35.
KHO,
K-O-I-R-A-N.
page number
35.
25,
35.
35. No, that's wrong.
K-H-O-I. Oh, yeah.
Be sure, Mrs. Sharma, what would be it? Khairani? That voter list of page 36 is the Assamese one. How will you write Khairani in English? KHOI,
K-H-A-I
AI, KHAI, RAN,
R-A-N-I.
Khairani. The the electoral roll of 2005, which is marked as Exhibit 4, contains the name of the petitioner with father's name as Yudhishthir of village Khairani. Full stop. Accordingly, it appears that the petitioner was a resident of the same village all throughout. Full stop. Next para the learned standing counsel for the FT matters, on a query of the court, has not been able to place any judgment which requires that electoral roll, the certified copy of an electoral roll is not an admissible evidence and is required to be proved by calling the authorities of the authorities under the Election Commission of India to exhibit a certified copy. So, on a perusal of the say exhibit numbers 1 to 4, it is seen that the said certified copies were issued by the election officer, Baksar, Musalpur. The tribunal has not recorded that the authority which has issued the certified copies was not competent to do so. Under such circumstances, the rejection of the exhibit numbers 1 to exhibit 4 on the ground that the competent authority is required to prove the same. Is held to be an erroneous decision by the learned member, Foreigners Tribunal, Baksar. Court is unable to accept that exhibit numbers 1 to exhibit numbers 1, number 1, TO2, exhibit number 4 which are all certified copies of the voter lists, would have been rejected summarily on the ground that the competent authorities are required to prove the same. Next paragraph, accordingly, comma. Notwithstanding that one part of the order cannot be faulted with in respect of that part of the observations in the impugn opinion that the petitioner could not exhibit any document between 1965 and 1997. Full stop, however, comma. As regards rejection of exhibit number 1 to exhibit number 4, comma, the impugn opinion is not found sustainable on facts and in law. Next paragraph, accordingly, comma, the court has no hesitation to set aside the impugn opinion dated 11/10/2000. No, not 11. It is 31/5/2018. Passed by page 26. Next paragraph, resultantly, comma, the matter stands remanded back to the said learned tribunal for a first decision after appreciating the evidence in accordance with law. Next paragraph. It may be mentioned that in the writ petition, the petitioner has annexed a certificate, a photocopy of the certificate copy of voter of electoral roll of 1985. The said document was never produced before the learned tribunal. Full stop. This court, in exercise of certiorari jurisdiction, would not appreciate the document which is produced in the writ petition for the first time, comma, having not been produced before the learned tribunal. Accordingly, comma, if any application is filed by the petitioner to consider any other document, comma, the same shall be considered by the learned tribunal in accordance with law. And without being prejudiced by this order. Next paragraph, accordingly, this writ petition stands allowed only in respect of that part of the impugned opinion dated 31/5/2018, page 26, by which the exhibit numbers, exhibit number 1 to exhibit 4 were discarded. With the matter being remanded to the said learned tribunal for a best opinion in accordance with law. Next, the registry shall return back the records of the tribunal expeditiously. Next para. The court is inclined to direct the petitioner, namely so and so, to appear before the tribunal within 30 days from the date of the order, i.e. within (10/4/2025), and by producing a certified copy of this order, wait for further instructions from the said learned tribunal. Next para. In the event the petitioner does not appear within the time allowed, comma, it would be open to the learned tribunal to treat the petitioner as absent on call and to pass a fresh opinion in accordance with law. 30 days time to appear. But if you don't appear, it will be at your risk.
Apply.
Item 22.
Yes, Lordship. Lordship, we pass over this matter for a day.
For the day,
For the day, Lordship.
see, what says the representative, pass over for the day as prayed for by learned counsel for the petitioner.
Yes.
(23).
Item 23.
There's no representation from the petitioner. This was the matter stands adjourned today for injured justice. Placed after 2 weeks. Mr. Sharma, the counsel on record in this matter was late Mr. Abu Sharif.
Yes, sir.
If you know someone from him, can just tell them.
Okay.
This is no more said therefore. (24).
Thanks for hearing, my lord.
Yes.
We have some difficulty on today, my lord.
Hmm?
Thanks for hearing, my lord. We have today some
Oh,
difficulty.
we are ready for hearing.
My lord, today is difficult.
No, we understand that. So far as we are concerned, both of us, we are ready.
Then, my lord, after 2 weeks.
Okay.
Yeah.
Okay. Both sides are represented. This after 2 weeks as prayed for by learned counsel for the petitioner. Yes.
Okay.
(25).
The petitioner was declared,
What is the best document you have to connect? What is the best document you have to connect you to your projected parents?
Lordship, in this matter, in the law code below, and the documents, lordship, there are 10 documents are exhibited, lordship. On 1951 NRC, then voter list of 1971, 1978, 2008,
No, no,
2009.
we know
and
whatever
certificate
was
number 1.
exhibited. We know what was exhibited. We are asking you, what is the best document you have to connect you to your projected parents? Showing that you were born to Indian citizens.
Lordship, this petition was filed against the opinion, lordship, dated 15 to 2018, lordship. We have filed this petition, lordship, because the linkage, lordship, 2000, lordship, 1951, lordship, NRC, page, lordship.
NRC, you
24.
already, NRC perhaps,
24 is.
NRC perhaps you already know the previous decision of this court on NRC.
NRC 1951 NRC, the petitioner's name is also there, his brother's names are also there, and his father's name is also there. Page 24, annex.
No, no, doesn't take you anywhere. You see, the document is at page 25.
25, lordship.
Correct. This is the document.
Lord-
Now, please tell me,
Yes, lord.
1951 NRC was prepared by whom?
Yes, lord.
Who prepared the NRC?
NRC was prepared, lordship, this was typed copy by the officer in the police station.
That's why we are asking you who prepared the NRC of 1951. Are you aware who prepared NRC in 1951? You don't know that. It was the Election Commission of India. Correct.
Yes, lord.
So does the officer in charge of police station at Borbeta, custodian of the records of the Election Commission of India, was he there? Is he the custodian?
Lordship, this NRC, lordship, this NRC was given by the officer in charge police station, lordship, type copy, lordship, when you apply it, lordship.
I understand. I also have a habit of giving certificate to anybody who comes to my chamber. I say all sort of things. Any member of the bar comes and makes a request to me, I don't refuse the member of the bar, I issue certificates. Correct.
Yes, lordship.
If you want, we'll also give a declaration that you are the president of India. Will it make you happy?
Lordship, in the office, it was, when he applied the NRC, lordship, in the office, lordship, of
I understand.
1951.
Since when Thana starts giving a certified copy? Under which rule the Thana is empowered to issue certified copy? Because administrative side, the High Court will save a lot of money. You see, we have to employ this public prosecutor's office, PI office in every court to issue certified copy. Our judicial department will save a lot of money.
This was taken from the exhibit 1 of the court below, lordship, tribunal below, lordship. On the certified copy, lordship. Which I have annexed,
Certified copy, you don't know, so your NRC goes. So other documents don't connect you. The voter list is not a proof of parentage. And other documents are post 1971. How do you show a link with your projected parents? Where is the evidence?
In the lordship, in the LCL.
Who came to?
Original copies in the LCL, lordship.
Okay.
उसी रिकॉर्ड हो जाता
Where is your written statement?
Okay, WS copy I have not annexed, I have with me, Lordship.
You see, Mrs. Gogoi, the evidence of DW2, it's not an acceptable piece of evidence. The petitioner, when when he filed his written statement and gave his evidence on affidavit, he does not introduce this Sohid Ali as his relative. This person comes and says that the
Lordship,
petitioner is his সম্পর্কীয় খুড়া।
yes, sir.
সম্পর্কীয় খুড়া is a very vague term.
The three, DW3 were there.
Because in the area where I was,
DW3 evidence does not correlate with the evidence on of opposite party. DW3.
no, but you see this term used, সম্পর্কীয় খুড়া, will be very dangerous. In the locality where I was born and brought up, every person I call is an uncle.
Lordship, in 1951 NRC, his name was there. with
You,
his,
you know, you may not be knowing. Mr. Sharma, I know from long time when I started my practice, I used to call him Dada. I still call him that. Outside this courtroom, I always call him Dada. But there's no connect. You don't find anything to connect you to your projected parents. You go to this because you'll be not there in the second half. So do we adjourn the matter today? Because this record you have to go through and then take your submissions. The written statement and evidence is not there. Okay. Let's say all sides are represented. Mr. G. Sharma, the next standing counsel for the FD matters, waits for some time to go through the records and address the court. Accordingly, matters stands adjourned today, this after 2 weeks.
It is your lordship. Item number lordship 28. It is already left over remaining last 8-9 days lordship.
Okay.
So I made a mention 20 case there is no protection to the petitioner lordship.
28.
Yes.
Okay, let me
Can you
reach
say
there.
Wednesday, your lordship is not sitting in the second half.
No, I did not say that.
Oh, lordship is sitting.
Second half. Oh, no. Second half, I'm there.
Item 2 fixed at 2.
This case, my lord, probably my learned friend was asked to get instruction
Yes.
why cross-examination date is fixed for cross-examination. But I have inquired, my lord, from the tribunal, and probably, my lord, as because there was no specific order that, my lord,
No, we understand. You see, there's no difficulty if the state wants cross-examination.
Yes,
But the tribunal can't fix a date for cross-examination.
yes, definitely, my lord. So, my lord, probably, my lord, for that reason only, the tribunal proceeded because this honorable court has observed.
No. The tribunal could have asked questions. We have no issue with that.
Yes.
But how can the suo motu court say that we'll cross-examine you?
That is wrong on the part of the tribunal. I have, my lord, said it cannot be done by the tribunal. Definitely, it cannot be done by the tribunal. There is no
Government,
application of
the government may
Yes,
file an application and
yes.
it will be considered.
that may be considered or that may
But
not be considered.
Tribunal may has the power to ask questions,
Yes.
but not to cross-examine. You want us to issue notice or we can dispose it off?
You'll also dispose of this 1 to 25 order may be set aside.
Heard Mr. A.R. Sigdel and the counsel for the petitioner. Also heard all the respondents are there, Mr. M. Islam on behalf of Mr. A. Ali. Next panel. Next, the case of the petitioner, in brief, is that the petitioner is suspected to be a foreigner of post 25/3/1971 series. And accordingly, FT case number 434 of 2015 has been registered against him, which is being tried before the learned member, Foreigners Tribunal number 2nd, Kamrup Metro, Guwahati. Full stop. The said learned tribunal had passed an opinion on 1/8/2018, declaring the petitioner to be a foreigner of post 24/3/1971 stream. Full stop. agreed by the said opinion, the petitioner had approached this court and by filing WPC 5911 of 2018, had assailed the said opinion. Post of this court, by an order dated 26/11/2024, passed in WBC 5911 of 2018, allowed the writ petition and the said opinion dated 1/8/2018 was set aside and the matter was remanded back for a fresh decision before the said learned tribunal. Next paragraph. The petitioner had appeared before the learned tribunal and had produced the certified copy of order dated 26/11/2024, passed by this court in WBC 5911 of 2018. And appeared before the learned tribunal on 20/12/2024 and produced the certified copy of order as well. So stop. The matter was taken up by the said learned tribunal on 1/2/2025 and the said learned tribunal by an order dated 1/2/2025 fixed the case for cross-examination of defense witnesses on 7/3/2025. Stop. The said order dated 1/2/2025, passed by the learned member of Foreigners Tribunal number 2, Kamru Metro Guwahati, is held in this writ petition filed under Article 226 of the Constitution of India on the ground that without any prayer by the state, the tribunal had suo motu, SUOMOTU, suo motu, fixed the matter for cross-examination of defense witnesses on 7/3/2025. Next matter. The learned counsel for the petitioner has submitted that the learned tribunal would have asked questions to the witnesses present, or the tribunal could have called for the witnesses to put questions as provided for under Section 165 of the Evidence Act, corresponding to Section 168 of the Bharatiya Sakshya Adhiniyam 2023. So, however, in the absence of any prayer made by the state, the foreigners tribunal is not empowered to cross-examine a defense witness. Next paragraph. The learned tribunal for the FT matters has submitted that as the matter was remanded back for a fresh opinion by the learned tribunal, or perhaps the intention of the tribunal was to allow the state to cross-examine the defense witness. And accordingly, he has submitted in support of the impugn order. Next paragraph. The order dated 1/2/2025 passed by the said learned tribunal is extracted below, page 28. Next paragraph. From the contents of the order dated 1/2/2025, it is seen that the learned tribunal has not recorded the presence of the government leader, assistant government leader, or any other state council for the FT matters. Post of the said order also does not reveal that any petition was filed by the state to cross-examine the defense witness. Full stop. The procedure prescribed under the foreigners within bracket tribunals order, 1964, the tribunal is not empowered to cross-examine a witness. So, how, the tribunal would have power to put questions in accordance with the prescription of section 165 of the Evidence Act, corresponding to section 169 of the Bharatiya Sakshi Adhiniyam, 2003. So 168 of Bharatiya Sakshi Adhiniyam 2023. This one. Next, cross-examination by a party to the proceedings stands in a different pedestal than examination by the court public tribunal. Next, under such circumstances, the court is of the considered opinion that the order dated 1/2/2025, by which the learned member, Foreigners Tribunal number 2, Kangaroo Metro Guwahati, has fixed the case for cross-examination of defense witnesses on 7/3/2025, is not found sustainable on facts and in law. So accordingly, the court has no hesitation to set aside and quash the said order dated 1/2/2025. Next, however, the court is inclined to provide that in the event the tribunal is of the considered opinion that it was required to ask questions to the defense witnesses, it would have liberty to do so. Post of however, such examination shall be recorded as questions by the court, questions by the tribunal, and not to be shown as cross-examination by the state. Next para. What is the next date now?
My lord, as per the this order 7-3, my lord. That has been also over, my lord. I
What
have
is the
no
next
idea,
date now?
I have no instruction, my lord. Last date was
Next
7-3.
date he may be,
Oh, okay,
next date
next
is
date.
probably.
As the next date of as the date of 7/3/2025 has already lapsed, comma, the petitioner is directed to again appear before the said learned tribunal on the next date fixed, without requirement of any fresh notice to be issued. On such appearance, or the petitioner shall produce a certified copy of this order and await for further instructions from the said learned tribunal.
My lord, one of the problem, my lord, we have indicated in para 10.
What
And
is
one
that?
of the witness, DW2, mother, now he's 80 years, 7 years old.
No.
And she has lost her memory.
No, let that be examined by the tribunal. If we, because at this stage we can't allow substitution. We can't, we can't make any order without knowing the condition. That would be the tribunal would be the best judge.
My lord.
If it is required, then only, my lord. If
lord.
it may not be required. Also.
No, we don't know, but
Yes,
see,
that's why.
because there is asking, has raised the issue, but
Yeah.
we can't say anything.
No, that's why, my lord, it is not yet started.
Because if you press that part and we put anything in the order, that will go against you.
My lord. My lord.
Well, stop there. Then
Yes, my lord. Developed.
the next paragraph, the repression stands allowed in the motion state without the issuance of notice on the respondents. Accordingly, comma, in the event, accordingly, comma, in the event any factor has not been correctly projected by the petitioner, comma, the state would have liberty to approach this court for modification of the order, if so
Fine.
advised.
26.
Please, your lordship. My lord,
Where is your written statement?
my lord,
Where is your written statement?
written statement, your lordship will find at page 28, my lord.
Hmm?
Page 28.
Which page is the link certificate?
Certificate, my lord.
Is it page 25?
My lord. Page 25, my lord.
But then you have no case. You have not been able to connect yourself to your projected parents. This exhibit K is inadmissible document. And look at your cross-examination at page 37.
Father's name is
That destroys your entire case.
here, my lord, in the proofs, my lord. It was stated my
That
father.
destroys your entire case.
Right.
This cross-examination destroys your entire case. Because you can't know, you don't know your family. Entries in the voters list, you can't say who is that, who are those persons whose name are entered into in the voters list. So they are not part of your family. Because the tribunal has rightly discarded your evidence. And except for voter list, you have no document to connect yourself to your projected parents.
I have only one uncle. I don't know Basiruddin, whose name was included in the evidence. Whether Basiruddin is his uncle or not. Basiruddin. He knows Basiruddin.
No, what the petitioner knows, I don't know. I have no personal knowledge. I'm just reading from the evidence cross-examination, and I'm saying that you have failed to prove from even from the voters list that they are part of your members of your family.
My lord, in the voter list of 1970, my lord, there is 66, my lord. There
You
is
see, entries in the voter list cannot create a family.
Kosaruddin was there, my lord, and it becomes Kosaruddin, my lord, in the say voter list of 1970.
Pardon me?
My lord, here in the voter list of 1966, my lord. Then I'm reading the name, my lord. Nasir Ali, Basiran Nisa, Kosaruddin.
You know, you are saying that your mother's name is there in 1966 voter list.
Yes, sir.
How do you connect yourself to your mother?
Rubia Khatun.
How do you connect yourself to your mother? What is the best evidence you have produced to connect you to your mother, except from voter list? You see, because if you try hard, there is also a possibility that you can get a voters list of electoral roll of Mr. Payang. But merely a voter list does not create a family.
Even and that the opposite party, as a daughter of late Muqsid Ali, inherited plot of land, which was possessed by her deceased father during his lifetime. And
Kindly repeat again, I missed it. Yes, please.
31, page number 31, my lord.
31.
My lord. Paragraph 17, my lord.
Paragraph 31.
Then page 31.
Page 31, paragraph
17, my lord.
17.
My lord. Then the opposite party,
His
as a
daughter of Muqsid Ali inherited a plot of land which was possessed by her deceased father during his lifetime. What is that exhibit?
it was exhibit 12.
Exhibit 12.
My lord, it is not annexed with this, my lord. Petitioner, it is.
No, that exhibit 12 is not also available in the
It is
in this record.
LCR, my lord.
It's not there.
Because it was discussed, my lord, in the opinion, my lord. Yes, 41, my lord. Second paragraph.
No, we'll show you why. Please skip over and come to your evidence. Page 36. You please come to page 35 first. Paragraph 14.
My lord.
This document is not an exhibited document. At paragraph 14. Correct. Come to page 36. This document is also not entered in the list of exhibits.
My lord, it was later submitted, my lord. Page 14.
Page
40, my lord.
14.
40 or 40, my lord.
40.
My lord. My lord. Below the list, my lord. Yeah, my lord. 114, 10, 16, OP has submitted a copy of the as exhibit 12.
Where you are reading?
My lord, here,
Page 40, yes. Where? Okay, OPS submitted a copy of Jawaharlal exhibit 12.
114, probably it was subsequently added, my lord. On 14, 10, 2016, my lord.
What is the name of your father?
Muqsid Ali.
You see, the tribunal has rejected Exhibit 12 for reasons assigned. We find it to be a group ground. You see, by Exhibit 4, 5, and 6, there are two more brothers. Their names are not entered in the Jamabandi as a legatee of your father. Correct. You look at the opinion, if you will come to page 39, it's a reference of 2008. This Namzari which you did was mutation order dated 12/8/2016. So your own brothers were alienated, and under the principles of Mohammedan law that can't be done. That's why the tribunal has rejected that. We don't find any infirmity.
That if there are other brothers, my lord, have no objection, my lord, then
Probably, that's why probably that name was mutated in the name of the
No,
petitioner.
we don't know that. You see, you are projecting,
Yes, yes.
you are projecting a mutation to be the, to show that you are a,
Daughter of
that you are daughter of this person. You have to show and produce us the order of mutation and say that the mothers had excluded themselves from the land. That thing you are not done, and therefore the tribunal arrives at a finding that exhibit 4, 5, and 6 show the name of your brothers who are not there in the land, and therefore it has been discarded. What is wrong about it? You see, there are no contemporaries records to connect you with your parents. So you are merely relying on certain entries made in the Jamabandi or in the voters list to say that they are your parents. Incidentally, there is a 15-year gap, which is not sufficiently explained.
When the petitioner's name appeared for the first time in the 1985 method.
So that means after 15 years gap,
At the age of
for that there is no explanation. Your entry in the country must be continuously shown. Somebody must have done schooling, then pre-university or class 12, then. So therefore there are record of continued stay in the country. Which is your first voter list?
57 maybe. Sorry, 85 maybe.
85.
Right.
Which page is that?
Is 21 maybe.
Page
21 maybe. NSLG. Her name has been written as Aksima, wife of Alimuddin. Subsequently, it was characterized. Along with her husband Alimuddin.
Yes,
Thereafter, my lord. Page 22, my lord, it is
pardon
19,
me,
page 22, my lord,
22.
my lord. And my lord, total list of 97, my lord. Yes, total list, my lord. And page 23, total list of 2016, my lord.
We are sorry we don't find any connect except for voters list. There's no connect of yours with your projected parents. And you see, even if we omit to discard this page 25, despite the same having this state emblem, yet this document is a hearsay evidence. The last line it says based on documents submitted by the applicant. So you produce some documents and they say it. So it's not a primary evidence. Neither it is based on the personal knowledge of the secretary, nor the secretary was called for an examined.
But actually, yes, but there are lapses from many side, my lord. Because hopefully, my lord, at the time of during the continuation of the proceeding, my lord, and mother was also alive, my lord. Father died in the year 2006, but mother, hopefully, mother was alive, my lord. Mother was not, my lord, given any evidence. Her uncle or brother, they were also there, my lord. But case was not, my lord, tried in a whole manner, my lord. Only petitioner's evidence was given and nothing else. Because her brothers were there, her probably her mother was also there, my lord. They could have called. And we can take fault on the part of the.
No, I can't say about others, but I can say for myself, if I was deprived of land
Appreciate that.
by my sister, I would not go to give evidence for my sister.
Of course, my lord. Appreciate it. The case could have been tried in better way.
I'm sorry, we dismiss it, we pass orders in the chambers. I don't have time today. Yes, Mr. Payan, you seem to support Mr. Hawk.
My lord, the tribunal has rightly discussed in page para 41, what the observation is there, my lord. The GP certificate is, apart from that, my lord, GP certificate was not examined. GP was not examined, no Panchayat secretary was not examined, and the document was not proved. And it is rightly pointed out by your lordship that, my lord, the certificate was issued on the basis of the, my lord, material submitted by the petitioner. Then in next para, page 41, my lord, next para, why the, my lord, learned tribunal has rejected the exhibit 12 is clearly discussed. So in absence of both these documents, there is no link at all. So tribunal has rightly decided against the petitioner, madam. That is my humble submission. So it may not be interfered by the Sunami. And there is no indication that, my lord, tribunal has not given any opportunity to the petitioner to produce any evidence on their part.
Okay. Let's say, Mr. S. Hawk, Mohammed S. Hawk, counsel for the petitioner. Also heard all the respondents are there. Mr. M. Ali, M. Islam on behalf of Mr. A. Ali, for respondent number 2. The submissions of both sides are concluded. Judgment reserved. You are relying on any citations, Mr. Hawk? Are you relying on any case laws? No. Okay.
My lord, one more prayer, my lord. Item number 33, my lord. My lord, I have some difficulty. I am to go to phone, my lord.
Item number
33, my lord. Can you take a
33.
Right. Next week,
Okay, 33 adjourn
I really appreciate. I'm sorry.
on the prayer made by learned counsel for the petitioner. 33.
Right.
Okay, adjourn on the prayer made by learned counsel for the petitioner. Just after 2 weeks.
I'm obliged.
Twenty-seven.
Here, the petitioner is referring to a sale deed of 1970. You've examined that? That was discarded. Page 24.
Yes.
That is one of the link.
Let it come for hearing, Manu.
Huh?
Let it come for hearing. Manu. In the meantime, I will go through the records.
Okay. Okay, then we proceed for hearing. You are already on not to be arrested or deported.
That is there.
Also, as a represented. The records of the tribunal is received. So accordingly, the court is inclined to issue rule returnable forthwith without requiring the petitioner to take fresh steps. Next, this is the matter for hearing in the month of June 2025. Interim order passed earlier stands extended.
Item 28.
Please, Your Lordship.
Yes.
In this case, while issuing notice, a direction was passed to bring on record some documents, Lordship. So accordingly, we have filed additional affidavit. And the voter list of 1970, 1985 and 1989 were again annexed, Lordship. And thereafter on 19/6/2023, another direction was passed that 1970 voter list and 1989 voter list are same person or not. So we have filed again another additional affidavit, Lordship. And while issuing notice, there is an interim order that till the next date fixed, the petitioner shall not be deported. Now, Lordship, the LCR has received.
But this 1970 voter list is where?
Lordship.
It still does not contain your name.
No, my name is not there, Lordship. My name is in the voter list of 1989.
That's why you see the question of the court was to explain why the name of Supritan Nessa
Supritan
wife
is my
did not
mother's
appear in
name,
1970.
Lordship. My mother's name. Lordship.
Okay.
For that only, we bring on record the 1977 voter list saying that the mother's name did not appear in 1966 and 70. So later on, we prayed for correction of the voter list. And accordingly, in the year 1977, my mother's name again recorded.
Where is that voter list of 1977?
In the second affidavit, Lordship, we have
Oh,
annexed. Additional affidavit, Lordship.
But if
that-
you improve your case like that, we'll not be able to follow it because we don't
Lordship.
read that much.
No, Lordship, these are only, I am saying the prima facie case. And in fact, Lordship, the petitioner contested the case by filing some exhibits, that is page 38, your Lordship can list. Voter list of 1966, Exhibit 1, 1970, Exhibit 2, which contains the name of petitioner's father and mother, Lordship, petitioner's father, Lordship, that is Karim Box, Lordship.
Which page?
Sometimes,
Which page you are referring to?
Lordship, impugn order is at page 38.
Yes.
Voter list of 1966, Exhibit 1, voter list of 1970, Exhibit 2, voter list of 1985, Exhibit 3, voter list of 1989, Exhibit 4. 89, my name is recorded
No.
for the first time along with my parents.
No, you see, there's another issue which will arise.
Lordship,
If you are showing us this page, the opinion of page 38.
Lordship,
Now you see somewhere in this order, the court had discarded the voter list of 1970 on the ground that it does not contain the name of your mother.
yes,
Correct. That evidence was never brought on record before the tribunal.
yes,
Before this court to bring a document on record would be an exercise of jurisdiction which we don't have. Under statutory jurisdiction, we only examine the correctness of the opinion. What is the deficiency is not for us to examine and to find it out. Notwithstanding that this court directed you to file an affidavit, but that would travel beyond pleadings and evidence.
but Lordship, the voter list of 1985, which I exhibited, it contains the name of mother, Lordship. Only a question was arose that why her name was not
No,
there in
Mr. Chaudhary,
66.
there's other issues. Because if you are suspected to be a proceedee
Lordship,
and you are relying on the voter list of your mother,
Lordship.
then her entry into the country must be explained continuously. The continuous stay in the country has to be explained. So if there is a voter list which is missing, we can't draw an inference that she was available in the country.
Lordship, her name is there before 1959-55 voter list also her name is there, Lordship. In some of the voter lists, her name did not appear. So we prayed for inclusion of name of my mother, Lordship. Accordingly, later on, Lordship, in the year 1977, it was corrected.
You see, come to your evidence that is not the case you have projected in your written statement or evidence.
Lordship,
This part is an explanation in this writ petition.
Lordship.
So that's why we are asking you that question. You see, this is an explanation which is not there in the tribunal's records.
Lordship.
So you'll have to convince us that in statutory jurisdiction, we can go into that, examine it and then pass orders.
But Lordship, even if we discard the name of our mother, Lordship, my father's name is there before 1971. That voter list is available, Lordship. Kindly see, Lordship, the
Just a moment.
1966 voter list.
Just a moment. Mr. Payan, I think Mrs. Chaudhary has made out a case for at least for admitting it for hearing. This we just sent across this document. You see, this is a next of kin certificate. If you'll come to the opinion at page 40, last 5 lines, it has been discarded as. Now come to page 40. Last 4 lines. Exhibit 14 is a computer generated copy of next of kin certificate as per office name is recorded as son of so and so. This uncertified copy of so and so cannot be considered as a valid piece of evidence. Now, you have to show us that this next of kin certificate is issued as a certified copy. It is never. But this is issued by the circle officer merely on the basis of a lot mandal's report. They cannot be a certified copy. Because A is the son of B is not in the government records. So nobody will issue a certified copy. And if this document is admitted, then the petitioner can show the link to their his projected father. And then comes the certified copy of the voters list. It contains the father's name, mother is not there. But even if he does not claim from his mother, the citizenship is claimed by the father. So if the father is there, then I think we should admit this for hearing.
It can be admitted, madam. Certificate.
Once we admit, she'll pay for bail. That is the difficult part.
Yes, Lordship, only not to be deported. Interim order was there. There was no bail, Lordship. So the petitioner is apprehended.
Let him appeal.
Okay, we give a bail then. But Mrs. R. Chaudhary, non-counsel for the petitioner. Also heard, respondents are there. Mr. H.P. Hazarika is for government. The records of the tribunal, which was called for, is received. So first off, the examination of records would require some more time. Next, accordingly, the court is inclined to admit this petition for hearing by issuing rule without returnable forthwith without requiring any first steps to be taken. Next para. The prayer made by the learned counsel for the petitioner for bail is opposed by the learned standing counsel for the FT matters. Next para. Considering the projection made in this petition, the court is inclined to grant bail to the petitioner, namely so and so, providing that in the event of his arrest, same condition, 5 rupees, 10 days time to take bail, rupees 5,000 to the satisfaction of
Superintendent of Police, Bongaigaon, Lordship. SP
Superintendent of
Border,
Police, Border, Bongaigaon. Next, the learned counsel for the petitioner shall inform the court as to whether the court on the next date as to whether the petitioner has taken bail. Next, this is the matter for hearing in the month of June 2025.
Deeply appraised, Lordship.
29 with 30.
So pursuant to this, a notice has been issued.
Notice was issued, my lord, and there is a report which says that he died. Now, my lord, I have checked the C file also, my lord. It's written in the envelope that person concerned has died, returned to the sender. Now, whether we'll go by that or we'll get a report from the concerned police,
We will get a report from the police, superintendent of
sir.
police border. Mr.
that will
Pai,
be proper.
Morigaon. No, Nagaon, Nagaon.
No.
As per death certificate, Miller, Abdul Jabbar died 6/12/2019.
6/12/2019.
Yes, Miller. And Shomoto case is registered on Miller, order dated 21/7/2023. That may be confirmed by the concerned SP Miller. No, that will be better. Certificate duplicate over Miller.
No, but
Guaranteed.
Mohammed Abdul Jabbar.
Yes.
Why is this WPC
5407
5407?
Nazrul Islam
Who is he?
is the son of the Jabbar.
Is son of Jabbar.
Yes.
Let's see, pass a common order. Include it petitions. In connection, all sides are represented. Next, in connection with WPC within bracket Suomotu, MOTU, Suomotu, 1 of 2023. I was seeing the office note dated 22/3/2024, indicating that notice issued to respondent number 1 by registered post is received back with postal remark, inverted commas, the man was deceased, so return to sender, inverted comma closed. Next paragraph. In the said context, Mr. A.M. Ahmed, Land Counsel for the respondent.
Actually, Miller.
Okay, you are petitioner here.
Yes, I'm.
Okay, the petitioner in WPC 5407 of 2019 has submitted that as per the death certificate
Yes.
of
No, 6/12/2019 expired. Right.
No, the, of Mohammed Abdul Jabbar, MD, Mohammed Abdul Jabbar, alias Jabbar Ali. In this certificate, what is the name?
Abdul Jabbar.
Abdul Jabbar.
Yes.
MD is there or not there?
No, there is no MD.
Okay, only Abdul Jabbar. Abdul Jabbar. Just show that. This document is available here.
Yes.
Did you produce it earlier? Yeah, no.
No, my lord. My lord, what happened in this case, my lord? Abdul Jabbar declared Indian, my lord, 2014, my lord. Page 37.
Oh, okay.
And he has reduced in this case, my lord. Repetition, my lord, 5407, my lord.
Okay, as per the death certificate
Most of the copy line.
issued on which was registered on 27/12/2019 by the registrar, birth and death, Samaguri, SAMAGURI, BPSC, late Abdul Jabbar, ABDUL, JABBAR, had expired on 6/12/2019. Full stop. Accordingly, next para, accordingly, as accordingly, it is deemed appropriate that a report be called from the Superintendent of Police, Border, Nagaon, to make an inquiry and to cause an inquiry and to submit a report as to whether Abdul Jabbar
Iman Hassan. Bukan Syukam no?
Abdul Jabbar, who is the proceedee of FT case number 142 of 2011, which were decided by the London member, Foreigners Tribunal, 2nd, Nagaon, by opinion dated 24/3/2014. Is alive and available or not? Next paragraph. The learned standing counsel for the FT matters shall send a downloaded copy of this order along with a photocopy of the death certificate produced by the learned counsel for the petitioner in WPC 5407 of 2019 to the Superintendent of Police, Border, which place? Nagaon. To cause an examination to send this report. Next para. List on. How much time, Mr. Panay? 2 weeks. Give a date. We'll sit on that day.
April Utia, Rosama. April 1st evening.
Second,
Okay,
Second of it.
2/4/2025. Okay. They just add there, before that, you see, no separate order is being passed in the. Oh, no, it's a common order, not required. That line is not required. Okay.
Fine. Highly publish.
31.
Just record the presence, Mr. S.K. Das for the standing counsel for the High Court in that suo motu writ petition. And Mr. A.M. Ahmed, counsel for petitioner into the other writ petition.
Public.
Give the name of the respondents also. Okay.
Thirty-one.
In 31 and 34, my lord. In both these two matters, my lord, earlier I was given time to produce some more documents, my lord. In one case, I got documents, other case, I have not got. So, my lord, I may be given some more time. So, lordship may admit this case for hearing. We are already in bail, my lord.
Well, the documents be there. We can't fix the matter for hearing without documents.
My lord.
Okay. Mr. Pine, we're giving 2 weeks time.
Yes.
Okay. 30. You want
31 and
adjournment?
34, my lord. 31 and 34.
31 and 34. Pass separate orders. Also as a representative on the prayer made by land council for the petitioner, please after 2 weeks.
My lord.
Thirty-two. No representation from the petitioner. For ends of justice, the matter stands adjourned today. All the respondents are represented. List after 2 weeks. Yes, 35.
May I present? Judgment, your lordship will find, my lord. Annexure 11, my lord.
Give us the page number.
Well, what happened, my lord?
Give the page number.
My lord, page number. Judgment, my lord, this starts from, my lord. My lord, Annexure 11, page 50, my lord.
What is the best document to connect you with your projected parents?
The petitioner had submitted, my lord, in his exhibit, my lord, his educational certificate, my lord. Firstly, my lord, Annexure 8, page 47, my lord, his admit for SLSC, my lord.
Page number?
47, my lord. That is, my lord, was exhibited as Annexure 3, my lord. Wherein, my lord, his father name is clearly shown, my lord. And secondly, my lord, Annexure 10, my lord, at page 49, my lord. This, my lord, higher secondary pass, my lord, 3-degree commerce final, my lord, examination, my lord.
Any document prior to 1971, either of yours or your project?
Parents, my lord, parents voter Please, my lord, of 1970, my lord, it was exhibited as, my lord, exhibit 2, my lord.
Exhibit 2, page.
Is, my lord, your lordship will find 46, my lord. The document also, my lord, his service certificate of his father, my lord.
Where is that?
That your lordship will find at page 44, my lord, exhibit 1, my lord.
How was this document dealt with by the tribunal? Which page?
These, my lord, all these documents were, my lord, sent for authentication before the concerned authorities by the learned tribunal, my lord. And all these authorities were, all these documents were found to be genuine, my lord. But the petitioner had not adduced any evidence to prove these documents, my lord. Only on that ground, my lord, the petitioner was, my lord, declared to be a foreigner, my lord.
He did not give evidence.
To prove these documents, my lord.
Where is the finding that the tribunal had sent the records to for
That your lordship will
authentication?
find, my lord, from page 66, my lord. Page 66. First, second, third, fifth para, my lord. In regard of exhibit number 1, in order to verify the authenticity and content of the aforesaid exhibit, a letter having so and so was received from the divisional personnel officer in reply to the notice being so and so, my lord, by the tribunal, wherein it has been reported that in reference to the above, it is informed that the certificate in the name of Monindra Lal De, son of late Rishikanta De, has been verified and found genuine. This is for your information.
What is the explanation for not appearing before the tribunal to give evidence?
My lord, these documents were sought to be verified by the tribunal, my lord.
Mr. Payan, if this is right, that the tribunal has sent, because I have not verified this particular record.
Yes.
If the tribunal has sent the documents for authentication, then the consequences of section 165 will follow. It's a document proved by the tribunal itself. It will require no further evidence. But still an evidence is required as the citizenship is in doubt. We'll have to remand the matter back to give an opportunity to the petitioner to prove the documents. Because 40, his father appears to be from 48 in the service of NF Railway.
48 to 28 to
1948 to 1982.
Let it be.
Otherwise, my lord, even the tribunal held him to be an Indian, but because the documents were not proved, my lord, that your lordship will find at page 87, my lord, second paragraph. The determining factor only relates to the not proving of any of the exhibits duly produced and exhibited by him, although verified in his defense to establish himself as an Indian citizen.
You're reading where?
My
87.
lord, 87 second para, my lord, from fifth line, my lord, determining factor, my lord.
Seven. Of T. Somewhere I read that this petitioner could not afford a lawyer.
Yes, my
That
lord.
was a plea taken. Where is that?
My lord, even it is mentioned in the judgment also, my lord.
Please show us that.
Represented by DLSA, madam. DLSA.
He was represented by DLSA, my lord.
DLSA.
Yes.
But look at page 52. You see, the proceeding was asked questions and he says that he came from Bangladesh.
No, man. No, that is, my lord, during inquiry, my lord, that is all the inquiry report, my lord.
Oh, police inquiry report.
Police inquiry report.
And where is that finding that he's represented by the legal aid counsel and he could not afford a lawyer? Where is that?
Lord, in the first page of the judgment also it is mentioned, my lord. For the proceedings, Sri Sudipta Ghosh Biswas, Advocate Dibrugarh for DLSA Dibrugarh.
No, it is on page 58. I told you this there, it has to be there. I just don't remember every page in every writ petition.
My lord, at page 58, my lord. He expresses incapacity to engage a lawyer of his choice due to financial constraints. A learned counsel from the Dibrugarh Legal Services Authority, Dibrugarh, has been engaged for the purpose to represent the proceeding.
Heard. Mr. S. Parashar, learned counsel for the petitioner, also heard. All the respondents are there. Mr. M. Islam on behalf of Mr. A. I. Ali. Next, pursuant to order dated 8/9/2023, or the records of the tribunal has been received. Where was the same? Next, the records reveal that pursuant to the notice issued by the learned tribunal, the petitioner had appeared before the foreigners tribunal Dibrugarh second, Dibrugarh. However, he had not filed a written statement despite several opportunities being granted. And he was also absent on call, and therefore, by an order dated 14/9/2021, bailable warrant of arrest for ₹500 was issued. And accordingly, on the next date fixed, i.e. on 4/10/2021, the petitioner had appeared before the tribunal and had expressed his incapacity to engage a lawyer of his choice due to financial constraints. So accordingly, learned counsel was engaged by the District Legal Services Authority, Dibrugarh. Thereafter, the petitioner had filed his written statement along with documents. And on 24/3/2022, the petitioner was examined orally. For proving his case. It is open. You see, just because of my bad habit of going through the tribunal records, they found something interesting. Have you, before you stood for argument, have you looked at the trial court records?
No.
No, you don't have time.
My lord,
You are doing a disservice. You are worse than the lawyer who appeared before the DLSA for the DLSA in the tribunal. You find a poor client and you don't deal with him correctly. In this case also, we should appoint a legal aid counsel to address us. Time and again, I say that please go through the records before starting your argument, and you don't have time. And all the busy lawyers, they will have time.
My lord, I have already gone through the deposition and
Then you should have addressed us that the exhibit 1 was proved.
yes, my lord.
You did not do it. It's a
Exhibit one-
disservice to your client.
Exhibit 1 was authenticated by the tribunal itself, my lord.
Authentication and the deposition are recorded by the tribunal are two different things. You don't go through the tribunal records and face criticism from the court. Please tell us if everything we have to find out. What is the utility of hearing a lawyer? I would have disposed of more matters in sitting in home and in my chamber than working in the tribal court.
All the documents were sent for authentication by the tribunal. All the
That's okay, we
original
don't hear
documents
you.
were submitted before the
We are not inclined to hear you. Mr. Pang, this is an exhibited document. How the court will not look into it? Why it should have been remanded at the first? Sorry, we shouldn't declare it foreigner.
They should exhibit it, man, all these documents. Tribunal has rejected only on the ground that, my lord, the author of the documents, they were not examined.
No, but look at the last. Not proving any of the exhibits. This is at page 87, paragraph 15.
He has not been mitigated through the pleadings and evidence produced by the continuous setting instructions. The determining factor only prove and a big duty produce and exhibit by him to verify to the such systems of movement. The determining factor only relates to not proving of any of the exhibits duly produced and exhibited by him, although verified in his defense to establish himself as Indian citizen.
There is perhaps incorrect way of dealing with the records. Just send back the records. Let me check the cover sheet.
Lordship will page 67, my lord.
We express our displeasure. We don't want to hear you. Uh, Just align the paragraph. Huh? I may have missed few words. You just add there those missing words. Next paragraph, the records reveal that on 24/3/2022, the proceeding was already examined on oath as DW1. So there appears to be no cross-examination by the state. However, the petitioner had given answers to the court queries. Accordingly, as per order dated 24/3/2022, the evidence of the petitioner was closed. By the said order, the evidence of the prosecution was also closed, as the post of assistant government pleader was lying vacant. As per the oral deposition of the petitioner as DW1, the petitioner claimed that his father, late Monindra, Monindra, Monindra Lal De, was a railway employee, and he joined service in the year 1948 and retired from service in the year 1982. He joined service in the year 1948 as Khalasi in the engineering department in Narkatia, and he retired from service in the year 1982. In this regard, the petitioner has exhibited a certificate issued by the divisional engineer, D full stop E full stop N full stop office, comma Dibrugarh, bearing serial number 72 dated 8/8/84 as exhibit 1. Full stop. In order to demonstrate that the petitioner's father had casted vote in the year 1965 and 1971, comma, the petitioner has exhibited the electoral roll of the year 1970 of number 121, Joypur, Joypur, Jaipur Assembly oblique Parliamentary Constituency. As exhibit 2. Most of the petitioner claimed that he was born on 2/9/1963 at Naharkatia Railway Quarter in the district of Dibrugarh, and he had appeared in his HSLC examination from Board of Secondary Education Assam in the year 1979, and he had exhibited the original admit card of SSLC, comma, issued by the Controller of Examinations, comma, Board of Secondary Education Assam as exhibit 3. For the examinations held in the year 1979. The petitioner has exhibited his HSLC pass certificate as exhibit 4. For the year 1979, and he has exhibited a college certificate of appearing in of clearing the pre-degree within bracket com COM bracket close final examination, comma 1983, comma issued by the principal, comma Naharkatia College on 22/9/1983 as exhibit 5. Full stop. Text para the records further reveal that the hearing of the argument was concluded by as per order dated 11/7/2022, and the next date of the case was fixed on 4/8/2022 for rendition of opinion. However, comma, as per order dated 4/8/2022, comma, the learned tribunal deemed it appropriate to call for the verification report in respect of authenticity of exhibit numbers 1 to 5. And accordingly, notices were issued to the authorities who had issued those exhibits to verify the authenticity of the contents. Full stop. As per order dated 16/9/2022, the election officer Dibrugarh had authenticated exhibit 2 to be authentic as per order dated 2/3/2023, it was reported to the Runner Tribunal that the process server, after inquiring at the Tinsukia DRM within bracket P bracket close office, could learn that there is no record available in the name of the petitioner's father, and the process server was informed that the relevant records are available with the Dibrugarh DRM within bracket P office. And accordingly, notice was issued to the said authority for verifying the authenticity of exhibit numbers 1 and 5. For direction issued to the Superintendent of Police Border, Dibrugarh, asking him to verify the authenticity of exhibits 1 and 5. Earlier statement is not there. Huh? Earlier one is not there. The second will remain, not the first part. As per order dated 27/4/2023, report on exhibit 5 was received. Authenticating the said document. In respect of exhibit 1, another report was received from the Superintendent of Police within bracket border, bracket close Dibrugarh, confirming the authenticity of exhibit 1. No, sorry, confirming that the records the records, strike out the only one, the records were sent by the divisional railway manager within bracket P, Dibrugarh office to the Tinsukia. And accordingly, a fresh notice was issued to the divisional railway manager within bracket P, bracket close Tinsukia. So as per order dated 1/6/2023, the office of the divisional personnel officer, on behalf of the divisional railway manager within bracket P, NF Railway Tinsukia, had confirmed the contents of exhibit 1 as verified and found genuine. Next paragraph. However, in the impugned opinion dated 13/7/2023, in paragraph In paragraph 12, the report regarding authenticity and verification of exhibit number 1 and 5. 1, 4, and 5. No, 1, 3, 4, and 5. Has been recorded. Full stop. However, the said learned tribunal had rejected exhibit 2, which is the certified copy of the voters list of 1970, on the ground that in his deposition, the petitioner had not deposed about his father casting any ballot in the year 1970, but had stated that his father had casted vote since the year 1965 and 1971 and continuously thereafter. And accordingly, it was held that exhibit 2 did not establish linkage of the petitioner with his projected father, and exhibit 2 was held to be not proved. So the so we'll have to rise. Okay, we'll continue dictation in the chamber. I have to rise.
A my lord issued, my lord directing me.
Lordship, if I may just submit one thing. Here, Lordship, by going to the records, Lordship, as well as after talking to the IO Lordship, I have realized that he has appeared before the IO Lordship. He was given notice the first time he did not appear, but the second time he appeared. Yes, he has appeared, Lordship. Now the thing is, Lordship, the original case, it has already been charge sheeted. And further investigation is going on, Lordship. And during that investigation, his name has cropped up, Lordship, from the interrogative statement of one Manospati Mohan, Lordship. And thereby, Lordship, in that accused mobile phone, some fraudulent educational certificate were found, Lordship. And in that regard, the certificate has already been sent. Mobile phone is being sent to the FSL, Lordship. So if Lordship permits me to submit, Lordship, in all honesty, Lordship, let him appear before the IO Lordship, and the case may be, the case diary may be called after 20-25 days, Lordship, for further.
Okay.
Only thing, Lordship, he will cooperate, Lordship, he will appear before the IO as and when called for. And if some questionnaire is put before him, Lordship, he may just reply to it, Lordship.
We won't say so much, but we will say that he'll appear and he'll
Yeah,
cooperate with
that's
the
totally fine,
investigation.
yes.
Heard Mr. S. Chauhan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned AVP appearing for the state. Next para. ঠিক হওয়ারই বলবো। ট্যাগটা উল্টা করে দিয়েছে। আর ট্যাগ আছে উল্টা আছে। It's there. It's just wrongly put up. Next para. Pursuant to the earlier orders, comma, the case diary is received by the learned APP and on 7/3/2025, comma, the learned APP took some time to go through the voluminous case diary and to address the court. Next para. Upon perusal of the case diary, it appears that there are certain incriminating materials against the petitioner, which is now being investigated. And it may also be mentioned that charge sheet against few of the accused has already been submitted before the learned trial court.
Two accused.
Two accused. And in the continuing investigation, comma, the name of the petitioner is cropped out. Next para. The learned APP has submitted that as per the case diary, the petitioner did not appear when the first notice under section 41 capital A CRPC was issued. So however, the case diary reveals that on issuance of a second notice under section 41 capital A CRPC, comma, he has appeared before the IO. Next panel. Considering the conduct of the petitioner that he had appeared before the IO and receipt of notice, comma, the court is inclined to grant interim pre-arrest bail to the petitioner by providing that in the event of arrest of the petitioner in connection with page 2, CID PS case number so-and-so, under section so-and-so, comma, he shall be released on bail on furnishing bail bond of rupees 15,000 with one surety of like amount to the satisfaction of the arresting officer. So the interim bail is granted on the following conditions. Next paragraph. As one of the conditions, you say that the petitioner shall appear before the IO within 7 days from the date of the order, and he shall cooperate with the investigation and shall appear before the IO as and when called for. Next paragraph. Let the case diary be returned and produced again on 2nd of April 2025.